all evidence. We haven't gotten to put on our case yet. And to the extent that this case proceeds, and that will start now. But this is all evidence that has come in while plaintiff.
That will start now. You know you're going to lose this motion.
Evidence has come in, and he can't overcome that. In this case, Your Honor, if Mr. Depp abused Ms. Heard physically, verbally, emotionally, or psychologically, even one time, then she wins on those.
Firmly disagree. That doesn't make her statement substantially true.
And the evidence is overwhelming and undisputed in the ways that I've just described that he did. So for that reason, Your Honor, those claims should be stricken. And I'll just cite the Union of Needle Trades versus Jones case, this 268 Virginia 512, that states if
Too many fucking money. Too many fucking money. Too many fucking money.
Account and said, look what I published yesterday in the Washington Post. So she adopted the title, and her name was on published yesterday in the Washington Post. So she adopted the title, and her name was on published yesterday in the Washington Post. So she adopted the title, and her name was on published yesterday in the Washington Post. So she adopted.
And I'm happy to hand the court the transcript of the April 8th hearing, because one of the things that we're not arguing today is that because they haven't put in evidence of the, I think it was a tweet, but Mr. Chu says it was Instagram, I don't know, whatever it was, that because there was.
It was a tweet adopting the op-ed she published the day before in the Washington Post.
Okay. All right. So what I'm not arguing today is that because they haven't gotten that tweet into evidence, or had Ms. Heard say that she tweeted that we're entitled to summary judgment at this point. I'm not arguing that, but that's all that we discussed on April 8th, and I'm happy to hand the transcript up, Your Honor. And we actually never, it wasn't a stipulation. It was simply an agreement that they didn't need to call her in their case sheet to make that point. And then Ms. Bredehoff said, we'd have to agree on the language of any stipulation. They haven't proposed anything to us and haven't gotten back to us. So I think that that's only relevant. We're not basing our request for a motion to strike here on Ms. Heard not having testified to sending that tweet.
But you're saying for the motion to strike, the only evidence before the court is that the Washington Post wrote that title.
Correct. And that's very different from what happened the next day. The stipulation didn't go toward who wrote the title. That was never part of anything. And it's undisputed, and Ms. Heard will testify that she didn't write the title.
Well, I understand that, but I think
I apologize for interrupting.
And she hasn't testified yet.
Is whether it was republication.
Well, I'll get to that next.
But the problem is, how do I do a motion to strike when that evidence isn't before me yet?
Well, the republication isn't. So the evidence that's before you is that the Washington Post wrote the headline, or that Ms. Heard didn't, and that's the only evidence, and that's not going to change. The tweet, which was the only subject of the discussion pre-trial, where there was no stipulation. It was just an agreement that we're not going to base a motion to strike on them not introducing evidence of the tweet. That was what it was. I'm happy to hand the transcript up if Your Honor would like to see that. But that isn't actionable because under the Lakova versus Halper case, 995/134, retweeting a link doesn't constitute republication. That case.
Well, it does if you add something to it. I just don't know the evidence.
Your Honor, very quickly, it's judicial admission. They admitted in Ms. Heard's answer, she admitted to the tweet. So that establishes that she adopted the op-ed in its entirety, and it was discussed. We talked about judicial admissions. One was the op-ed itself. The second, and this is reflected.
Your Honor, if I could finish my argument, I mean, I would
understand.
appreciate.
I can't wait to oppose this.
You understand my concern.
I do understand your concern, and I guess. There's two levels. One is, there's no dispute, and there's not going to be a dispute that she did not write the headline. So then you look at, is the tweet actionable? And the argument here is that as a matter of law, retweeting something isn't actionable. And so, as under the Lakova case, 995 F.
It's a different question,
When that
though.
case dealt with hyperlinks.
And you know
hyperlinks
it.
aren't actionable. But to be very clear, nothing that was discussed on April 8th, nothing that was discussed at that pretrial conference was in any way relating to any stipulation about who wrote the headline. It was simply that they need not call Ms. Heard in their case in chief to get her to say that she sent a certain tweet. And that tweet's not in evidence yet, but I assume that they'll try to put it in evidence at some point. But the tweet doesn't need to be in evidence for you to strike this claim on that basis. So, even assuming that the headline implied certain conduct by Mr. Depp, again, Mr. Depp can't meet his burden of proof.
Of course he is.
He can't prove that Ms. Heard acted with actual malice. Mr. Depp hasn't introduced evidence sufficient to permit him to meet this. Now, again, this is a heightened burden of proof. He has to show actual malice by clear and convincing evidence. And as the Bose Corporation case from the U.S. Supreme Court, it talks about the role of judges as gatekeepers of the Constitution, of the First Amendment, and the role of barring entry of a judgment that's not supported by clear and convincing proof. Now, that case was about appellate review of First Amendment issues, but the same holds true for Your Honor here. Here, he hasn't introduced, Mr. Depp hasn't introduced any evidence, and there can't be a reasonable inference drawn that would permit a jury to find that he's proven by clear and convincing evidence that Ms. Heard wrote the words with actual malice. And again, we go back to the testimony of Mr. Doherty, which was their witness.
Yeah.
They put him in, and Mr. Doherty, the only evidence relating to intent or anything relating to this op-ed, which was, again, maybe Mr. Chu will try to say that we stipulated to Ms. Heard's intent on April 8th, which of course we didn't. But the only evidence that has been presented in this case by Mr. Doherty was that the op-ed wasn't Ms. Heard's idea, that the ACLU asked her to write the op-ed, and indeed that they even wrote the first draft, and then that Ms. Heard vetted the finished article with her lawyers and with lawyers from the ACLU to make sure that it wasn't problematic. That is the only evidence in the record. And on that evidence, there cannot be a conclusion that Ms. Heard acted with the actual malice that's necessary, particularly when you consider the heightened burden of proof.
I would love to argue against this too.
So reviewing the op-ed as a whole, with the court acting in its appropriate function as a gatekeeper of the First Amendment, we ask that the court strike the plaintiff's evidence and award to Ms. Heard, either in whole or in part. Thank you.
All right, thank you. Yes, sir.
Real quick to the audience, this is normal after the one side rests for the other side to move for dismissal.
Benchu stands up and unzips his pants.
So the idea is right now the other party has an opportunity to win the case outright, even if it's not a very good opportunity. You
I
take it
just handed
because you might win it.
Mr. Rottenborn and Your Honor an opposition that we prepared before we had the benefit of seeing Ms. Heard's affirmative motion to strike, but I think we've anticipated the arguments made, such as they are. The court should deny defendant Amber Heard's motion to strike because Mr. Depp has come forward in his case in chief with multiple credible witnesses, documents, and authentic tape recordings of Ms. Heard herself, not only satisfying all of the requisite elements of his claim for defamation, including actual malice, but also going the extra mile of showing that Ms. Heard physically abused him. She's the abuser in this courtroom. Your Honor, going back to the standard, as Your Honor, in considering a motion to strike, the trial court must view the evidence and all reasonable inferences drawn from the evidence in light most favorable to the plaintiff. Any reasonable doubt as to whether the plaintiff has produced sufficient evidence of the wrong alleged must be resolved in the plaintiff's favor and the motion to strike denied, unquote. And that's the Boeing case, I believe Mr. Rottenborn referred to, 243 Virginia 81 at 81, 1992. Quote, the weight and credibility of the testimony of witnesses are solely matters for the jury. The jury may accept that part of the testimony it believes and reject that which it does not. It is also within the exclusive province of the jury to draw any reasonable inferences from the evidence before it, citing Rate versus Minix, 275 Virginia 579.
Notice the difference in confidence levels between the two lawyers.
In deference and respect to the court's time, Mr. Depp incorporates by reference the legal analysis set forth in the court's opinion letter dated March 27, 2020, overruling Ms. Hurt's demurrer to the 3 defamatory statements at issue. And that letter of Virginia Exhibit 1 to Mr. Depp's opposition. That's where the court fulfilled its proper gatekeeping role that Mr. Rottenborn referred to. As a threshold matter, the elements of a defamation claim are the following: publication of an actionable statement with the requisite intent, citing the Shaker versus Default case 290 Virginia 81 at 91. As to damages, they are presumed here because Ms. Heard's false allegations of domestic abuse, sexual assault, and rape constitute defamation per se, citing the Tronfield case 272 Virginia 709 713, a 2006 case. As the court noted at page 3 of its opinion letter, typically an editorial or op-ed column is ordinarily not actionable because it appears in a place devoted to or in a manner usually thought of as representing personal viewpoints. However, Virginia recognizes that, quote, a defamatory charge may be made by inference, implication, or insinuation, citing the Carwell case. And a statement expressing a defamatory meaning may not be apparent on its face, citing Pendleton, with which the court is quite familiar, 290 Virginia at 172. Accordingly, in order to render words defamatory and actionable, it is not necessary that the defamatory charge be in direct terms, but may be made indirectly, and it matters not how artful or disguised the modes in which the meaning is concealed, if it is in fact defamatory. Carwell, 196 Virginia at 7. And based on the authority and reasoning set forth in pages 4 through 8 of the opinion letter, the 3 statements at issue are actionable under a theory of defamation by implication. Mr. Depp established in his case in chief that Ms. Heard, in fact, made all 3 of the defamatory statements at issue. As the court admitted into evidence as Plaintiff's Exhibit 1, the op-ed Ms. Heard published in her own name in the Washington Post on December 18, 2018. And let's take the 3 statements and the proof that has been adduced. Statement number 1, Amber Heard, quote, I spoke up against sexual violence and faced our culture's wrath. That has to change. Per page 6 of the opinion letter, the first statement could reasonably convey the alleged defamatory meaning, i.e. that Mr. Depp abused Ms. Heard, to its readers without extending the words beyond their ordinary and common acceptation. See Pendleton, 290 Virginia at 172, also citing the Carwell case. Resolving every fair inference in Mr. Depp's favor, this statement could reasonably imply that the sexual violence Ms. Heard spoke up against was in fact perpetrated by Mr. Depp. Mr. Depp produced several credible witnesses and documents proving that Ms. Heard was implying that he committed sexual violence against her.
No, the jury's not
Depp
present, guys.
himself testified to that, as did his sister, Christy Dombrowski. Mr. Depp's former agent, Kristen Carino, testified that, as did his current agent, Jack Wiggum. But perhaps most convincing of all, and most disgusting of all, was the testimony of the ACLU's Terrence Doherty, a lawyer nonetheless. Mr. Doherty testified, among other things, that when when they were pitching the op-ed to the Washington Post, they stated, hey, Michael, Wonder if we might interest you in a piece by Amber Heard, who, as you may recall, was beaten up during her brief marriage to Johnny Depp, on what the incoming Congress can do to help protect women in similar situations. Mr. Doherty also testified that everybody understood, as Ms. Heard in the ACLU clearly intended, that this statement and the other two statements referred directly to Mr. Depp. Quote, "This is an article that was in USA Today and specifically ties Amber's statement in her op-ed piece to Johnny Depp." And when Jessica White, who actually wrote the op-ed that Ms. Heard later adopted, she says, quote, to Mr. Doherty, "So much for not mentioning JD," when the USA Today made clear that they, like everybody else who read the op-ed, understood that, as Ms. Heard clearly intended, it referred to Mr. Depp, which makes her Instagram post 2 days before the trial began, that she didn't mention Mr. Depp, all the more outrageous. Your Honor, there is Ms. Schulman, also of the ACLU, acknowledged that Ms. Heard's op-ed referred to Mr. Depp. So it's very clear that the ACLU and Ms. Heard intended, that was the whole purpose of this, so that they could get interest in this and it would coincide with the premiere of Aquaman, because otherwise no one would have been interested in anything written by Ms. Heard. Mr. Doherty also testified that Ms. Heard only paid 1.3, actually she didn't even pay all that, out of the $3.5 million that she had pledged to the ACLU. And then they helped her lie about it. And it's one thing, Your Honor, for her to sift the ACLU, which frankly played a reprehensible role in this case. It's quite another for her to fail to honor her obligation to the Children's Hospital of Los Angeles with sick and dying children. And that she failed to do as well. And as Your Honor has mentioned, the fact that she put her name on that article means that she is responsible for all of those statements, which she specifically adopted later. And I'll go through the other two statements quickly, Your Honor.
Well, can we stay on this for one moment, though?
Yes, Your Honor.
Because do you agree that the only evidence before that we've heard in this trial, as far as the title of the op-ed, is that even Mr. Doherty, I believe, testified to it, that it was something that Washington Post wrote?
Well,
For the one online.
he's not our witness, Your Honor. That's a witness from the ACLU.
Well, I understand, but it's the only evidence I have.
I respectfully disagree, Your Honor.
All right.
What the only real evidence Your Honor has is Plaintiff's Exhibit 1, which is Amber Heard putting her name on the entire article, including the title. That is the only evidence before you. The ACLU was a co-conspirator with Ms. Heard, and whether they say, oh, maybe the Washington Post wrote it, that's not the end of the story. All she has done is create an issue of fact as to whether she wrote the title or not.
So you're saying just having that exhibit in evidence is enough?
Absolutely, Your Honor. Her name is on the article. Okay. What does an average reader expect?
Bring the Washington Post headline writer in to refute it.
The motion to strike. If they want to come back later and say, gee, she didn't write the title, as if that were a defense, I hope they make that argument. I hope they make that argument to the jury, because it's about as credible as her argument that, oh, I wasn't referring to Johnny Depp. She didn't have to. And the testimony of Terrence Doherty was very clear that when they took out the references to Johnny Depp, no one was interested in this article anymore. So she said, put it back in, make it more spicy so people would read. Otherwise, she couldn't get it in the Washington Post. It would be back in Teenage Vogue, which was the other publication that was considering publishing it, because no one was interested in what she had to say, unless she was defending Mr. Depp. But if I could go to the second statement, I'll try to be quick on it. 2 years ago, I became a public figure representing domestic abuse, and I felt the full force
History being made right here.
for women who speak out. As for the second statement, defendant called herself a public figure representing domestic abuse, which can be read to imply that she became a representative of domestic abuse because she was abused by Mr. Depp, not just because she spoke out against alleged abuse. This inference can be drawn without extending the language beyond its ordinary common acceptation, citing Carlisle, 196, Virginia at 8. Your Honor, quote, to constitute a publication, it is not necessary that the contents of the writing should be made known to the public generally. It is enough, it is said, if they are made known to a single person, unquote, citing Snyder versus Fatherly, 158, Virginia, 335 at 350. Everybody and his grandma testified that Ms. Heard was referring to her bogus ex-parte TRO that she obtained on May 27, 2016. And it was interesting that Mr.
We're getting a nice person closing.
Said that she wasn't even provided notice. So Ms. Heard made very sure that Mr. Depp wouldn't have notice of the ex-parte TRO. And Ms. Heard herself, the evidence shows, knew that Mr. Depp, having just suffered the loss of his mother, was already on the other side of the country, was already in New York at the time of his TRO, and was heading to Europe for several weeks. So she knew she didn't need any protection from him. This was just a scam for her to get the $7 million in the divorce settlement that she said she gave to the ACLU. She swore she gave to the ACLU and the Children's Hospital of Los Angeles, and she pocketed it instead. Mr. Depp, Mr. Dombrowski, Mr. Farino, Mr. Wiggum, and the inimitable Mr. Doherty of the ACLU, which lent its once respected name to Ms. Heard's defamation.
Going hard.
So while Ms. Heard may have avoided any direct mention of Mr. Depp's name, there is extensive testimony and evidence in the record showing that the implication of her op-ed could not be more clear, i.e., that Mr. Depp abused Ms. Heard during the course of their marriage. Under Virginia law, quote, it is not necessary that the defamatory charge be in direct terms, but it may be made indirectly. And it matters not how artful or disguised the modes in which the meaning is concealed if it is in fact defamatory. Citing Carlisle, we can argue as to how artful it was, but the implication was very clear, as the court has previously ruled, or not law of the case, but as the court has persuasively written in its opinion letter. Let's move to the falsity of Ms. Heard's ever-evolving and ever-escalating change of IPV and sexual assault. Mr. Depp's sworn denial is all he needs to survive a motion to strike, but there's a lot more than that, Your Honor, and I'll try to be brief. 3 police officers, actually 4, but the 3 who testified already, Officers Sines, Haddon, and Gatlin, testified unequivocally that Ms. Heard did not have a mark on her on the evening of May 21, 2016. And I could go through, I'll just go through very quickly. Officer Haddon, strike that, Officer Melissa Sines on jury trial day 10. Question, did you provide a copy of this pamphlet to Amber Heard? Answer, I did not. I didn't identify her as a victim of domestic abuse. Next day, Officer Melissa Sines. Okay, at this time, did you notice any injuries on Ms. Heard? Officer Sines, I did not. Question, okay, were you looking to see if she had any injuries on her at the time? Officer Sines, yes, I was. Question, and so you were looking to see if Ms. Heard had any injuries and you determined that she did not. Is that accurate? Officer Sines, correct. Question, okay. And was the lighting good enough in the hallway for you to make that determination? Answer, yes, the hallway was well lit. Officer Gatlin's testimony was the same, and he had the body cam. Officer Haddon's testimony was the same. The testimony of nurses Debbie Lloyd and Erin Boran, who, like the police officers, did not work for Mr. Depp. In fact, they worked for Dr. Kipper, also belied Ms. Heard's false allegations of abuse. Isaac Baruch and Alejandro Romero both testified that they saw Ms. Heard repeatedly and in the clear light between May 21, 2021, which was the last time Mr. Depp saw her before leaving on the Hollywood Vampires tour. The next time he was to see her was when Ms. Heard begged him to come see her in San Francisco, which is hardly the act of a domestic abuse victim. So we have Isaac Baruch and Mr. Romero saying that they saw Ms. Heard repeatedly in the interval of time between May 21 and May 27, when she obtained the farce ex parte TRO, and they saw no marks on her face and no swelling. Two witnesses, Mr. Baruch and Brandon Patterson, saw the video of Ms. Heard and her sister Whitney pantomiming the fake punch after this alleged incident of abuse. Ms. Heard's former personal assistant, Kate James, and several other witnesses, including Dr. David Kipper, saw no violence by Mr. Depp and no injuries to Ms. Heard. Indeed, witness after witness has come forward to testify that Ms. Heard, far from being a domestic figure representing domestic violence, unquote, is in fact a recidivist perpetrator of domestic violence on Mr. Depp and others. We have the testimony, the harrowing testimony of Mr. Depp himself, who described several witnesses. One, Your Honor will recall, when he was hiding in the bathroom after escaping one of her attacks, and she claims to have hurt her foot kicking the door. Mr. Depp opens the door to see if she's hurt, and then she kicks the door in on him and punches him. We have the incident of December 15, 2015, when Ms. Heard threw punches at him wildly at the back and side of his head. Mr. Depp testified that he ducked and covered to protect his face. Eventually, he turned around to grab her and stop her arms from flailing. December 15 in the Bahamas, during an argument, Ms. Heard grabbed a can of mineral spirits and threw it at Mr. Depp's face, striking him in the forehead, bridge, and nose area, and the jury saw a photograph of the bridge on the bruise of his nose. We have testimony from Mr. And by the way, Tara Roberts, who is the manager of the island, confirmed that the incident with the mineral spirits. You have Mr. Depp's testimony of what happened on April 22nd, 2016. And we've heard testimony today from Aaron Boren Pilati that Mr. Depp was very responsive, was very sociable, was not in any way inebriated that day when Ms. Heard says he was, and she attacked him that night as well. And I'm getting to the end of this, Your Honor.
This should be plenty sufficient to survive the motion to dismiss. There's at least a fact question here.
We have Ms. Heard's own admissions. We have her admitting to hitting Mr. Depp, and her only contention was that she wasn't punching him, she was just hitting him. We have testimony from Travis McGivern that on February 23rd, 2015, Ms. Heard threw and hit Mr. Depp with a can of Red Bull and then sucker punched him with a closed fist. Finally, we have the rather stunning testimony of Ben King, quite a credible witness who accompanied Ms. Heard on the flight back from Australia, where Ms. Heard admits to him in a rhetorical question, quote, "Did you ever totally lose it on someone you love?" Which was, we would respectfully submit, an admission of her severing the top or the tip of Mr. Depp's finger. Finally, Your Honor, statement number 3, quote, "I had the rare vantage point of seeing in real time how institutions protect men accused of abuse." Again, quoting very briefly from page 7 of the court's opinion letter, quote, "Drawing every fair inference in plaintiff's favor, the court can fairly conclude the defendant's statement that she saw how institutions protect men accused of abuse could reasonably convey to its recipients that she saw how Mr. Depp was protected by institutions, that he abused her and spoke up against it." Your Honor, again, we have multiple testimony from multiple people, including Jack Wiggum and all the others mentioned, that this was a reference to that. Your Honor, again, the lies that have already been exposed that Ms. Heard has told about the charitable contributions, the incidents in this case, and again, I'll just cite a couple of more, the testimony of Isaac Baruch. When Mr. Baruch saw Ms. Heard on June 3, after she'd gone through with the sham ex-party TRO, and Mr. Baruch was asked, did she say anything in response? And Mr. Baruch testified, yeah. In response to that, she, meaning Ms. Heard, looks at me and said, I told Johnny I don't want anything. The lawyers are making me do all of this. And that's what she said. Well, the lawyers are making her do all of that. And apparently she wanted the $7 million for herself. She even lied about the final insult left on the marital bed after her 30th birthday party. And it was quite telling that she admitted to Starling Jenkins, a former United States Marine, that this was a terrible prank gone awry. Well, she lied about that too. In fact, she said Mr. Depp was crazy to even allege that she could have done such a thing. Well, she admitted it to Mr. Jenkins. Per Tronfield, as cited earlier, Mr. Depp does not have to prove damages because this is defamation per se. In fact, these involve some of the most heinous crimes any man or woman can be accused of. However, he has done so. Jack Wiggum tested yesterday that the impact of the op-ed was catastrophic on Mr. Depp's personal and professional life. That it was a $22.5 million loss on Pirate 6 and another $20 million on others. We've had the testimony. So we had Mr. Wiggum testifying as to the 22.5 lost on Pirate 6 and another 20 lost on the other films, the other studio films, the indie films, and the other ways Mr. Depp would have made income. We have Richard Marx's testimony, Douglas Banya's testimony, and the testimony of Michael Spindler just this morning. Finally, Your Honor, none of Ms. Heard's affirmative defenses, which would include, her trying to create an issue of fact on the title, can support a motion to strike, as to which she bears the burden of proof of her affirmative defenses. Quote, whether the defendants have met their burden cannot be resolved when considering a motion to strike. See 243 Virginia at 83. And just to respond to Mr. Rottenborn's citation to the Lakova case, which we hadn't seen until he mentioned it today, I would only note, Your Honor, that defendant admits that she tweeted a link to the online version of the op-ed at paragraph 97 of her answer, though again, the admission of Exhibit 1 is more than enough to survive the motion to strike. And the Lakova case at 995 F. 3rd 134 holds that republishing a hyperlink doesn't necessarily start the statute of limitations, not that a hyperlink cannot be defamatory. So with that, Your Honor, we respectfully request that the court deny the motion to strike in full, and let's hear from Ms. Heard.
Nailed it.
Thank you.
You did a very thorough
Excellent work.
defense.
That was beautiful. I can only assume that Mr. Chu wrote that speech for an audience outside the court because it didn't really address my arguments. I'm going to focus on what our specific arguments are for the motion to strike, Your Honor. Mr. Chu
He gets his
spent
response time, I suppose.
almost 30 minutes of the court's time talking about the disputed evidence of physical abuse in this case, which Ms. Heard hasn't even put on her case, and I can tell you she's not the abuser, and if the case moves forward, she and her witnesses will put on even more evidence of the physical abuse she suffered at the hands of Mr. Depp. But that's not the basis for our motion right now, Your Honor. He talks about how Mr. Depp had a sworn denial, and that should count. We read his testimony. He claims he didn't strike her. But again, that's not the basis for our motion. The basis for our motion is the clear and undisputed evidence of non-physical abuse. By his definitions, his standards, by the standards of his expert, there is no dispute that Mr. Depp abused Amber. And therefore, if he did it even one time, there's no dispute that even under their
The
theory
line
of
in the
case,
op-ed
the
is
implication
domestic
that they want the jury to
violence.
draw from the article,
Not
which again,
abuse.
I'm not arguing for the purposes of today, because under the legal standard, I'm not going to argue that. I'm not going to waste the court's time with that. But even under their standard, the undisputed evidence is that Mr. Depp did commit abuse against Ms. Heard, and therefore that those first two statements were false. That's our argument on that. As to the headline, it's funny, Mr. Chu, we played 2 or 3 hours of an ACLU deposition. Now he says, well, that wasn't our witness. It was his witness, Your Honor. He just spent 10 minutes talking about what Mr. Doherty said. And Mr. Doherty testified that the Washington Post wrote the headline. That is the only evidence, Your Honor. I understand he says, well, Exhibit 1 has her name on it. Exhibit 1 has her name on it. But the only evidence in this case about who wrote that headline is Mr. Doherty's testimony. It is
The jury is free to disregard that evidence or not believe
They
him.
could have called Ms. Heard for that because that was not part of
They're the finder of fact.
at the pretrial conference. It was only the tweet that we talked about, Your Honor, and they chose not to do that. Now, Ms. Heard will testify she didn't write that headline, so it wouldn't have helped them. But they've had 3 weeks to put on their case, Your Honor. They've controlled the playing field of evidence. There is no dispute that Ms. Heard did not write that headline. No dispute. Simply saying, well, her name is attached to it, that can't overcome the testimony of the ACLU. They call them a co-conspirator. Of course, Mr. Depp chose not to sue them. But the testimony of Terrence Doherty that she didn't write that headline, that takes care of the sexual violence headline, Your Honor. And I'm not going to take up any more of the court's time addressing portions of Mr. Chu's argument that don't go to our motion, unless Your Honor has any specific questions. But I want to be respectful.
All right,
Thank you.
sir. All right. For this motion, I've taken the arguments of counsel, and last night I reviewed all of the evidence that has been submitted in this matter. So as to the second and third alleged defamatory statements, the motion to strike at this juncture, I view the evidence in light most favorable to the plaintiff and reasonable inferences from the evidence.
Gonna get knocked out first.
Until
She's
it's
not
ever
knocked right.
reasonable juror could weigh, then the matter survives the motion to strike.
There we go.
In this matter, there is evidence in the case that a jury could weigh that the statements were made by the defendant, that the statements were about the plaintiff, that the statement was published, that the statement is false, and the defendant made the statement knowing it to be false, or the defendant made it so recklessly as to amount to a willful disregard.
He did, man. She already made her
The weight of that
decision
evidence is
before
up to
they
the
got
fact
it.
finder. So the motion.
Oh, she knew this would happen. She had this pre-thought out.
The motion to strike as a statement one, I'm going to take under advisement because if it's not a stipulation, I'm not sure what it is, but there seems to be an agreement that the tweet of Ms. Heard is part of the plaintiff's evidence, which is not in evidence at this point. So I can't rule on that statement whether or not it is just a tweet or if it's some sort of republication or something.
Submission
I don't
and
know.
her
I
answer,
haven't
though.
seen it yet. So as to the motion to strike on statement one, I'm going to take under advisement because ruling on it now, it would be premature. I just don't have that evidence in the case, okay?
Thank you very much, Ron.
All right, since it's 12:30, we want to just take lunch.
Lunch break,
Go ahead and let the
and
jurors go to
then-
lunch and come back at 1:30. Does that sound okay?
Yeah. Ben Chu has to go pound one out in the bathroom after that.
I mean, she knew that was coming. She thought about this probably over the last 3 days and all knew what her answer was gonna be.
Oh my God, that was. It's like a lawyer's wet dream right there. Was the plaintiff's response to the, like he said, it was just so beautifully articulated and so well said. I mean, it's so worth coming on today, Nick.
Oh, his response was beautiful because, it seems like he wrote that speech for an audience outside of the court. That's when you know that he's going home and putting on the butthurt cream. Because he got torched. He knows his argument got completely torched. They're still mad that this trial is public because Amber Heard looks bad, and they know that she fired her entire PR team, and she's looking at them going, why haven't you guys made me look good? I imagine there are some really nasty exchanges going on after some of these courtroom days with her attorneys and her. And they're smiling when they're leaving the courtroom, and she gets on the phone. She's like, hey, by the way, why is every headline I'm reading talking about how I'm an evil, abusive bitch? Why do all of them say that? Like,
This is not what I signed up for, you guys. This is not what I heard on the, what is it called? The Me Too movement? Yeah. This is, I'm supposed to be attached to the good side. How did you make me the devil?
Exactly. It is.
This is your fault. You know, the lawyers. I didn't do any of this. This is your fault. I'm sure she's pointing fingers.
Yes. Yeah, because that's what she's done. I mean, she fired Obama's PR team. Like that's who she had. It's crazy.
That's insane.
Who she had representing her in the court of public opinion, she's getting just brutally killed on it. And if anybody needs any evidence that a jury could find that maybe she's the abuser and Johnny Depp isn't, they're like, look no further than the court of public opinion. Doesn't guarantee that a juror is going to find that way, but a massive audience has found that way. And it's not just like people who watch a particular thing. If you're watching here, if you're watching Legal Bites, if you're watching Long Crime, watching anywhere, you're going to find typically you're typically going to find the majority of people on Johnny Depp's side, which is crazy to think about. How quickly his reputation has flipped on this thing.
I've noticed several articles since this trial has begun, and very just randomly scattered across the internet of, you know, one concept that we're very, very familiar with is toxic masculinity, right? I mean, that term gets thrown around left and right. Now, a new term, for me, at least from my personal observation, a new term that I've noticed with this trial that's being thrown around is toxic femininity. Trying to attach Amber Heard's treatment of Johnny Depp as such. And again, I think it's a lot of feminists, and a lot of these articles written by feminists trying to argue that, like, female abuse does not exist, and trying to defend Amber Heard under any circumstances. Doesn't matter what the facts are. Doesn't matter what we hear. Doesn't matter what the public opinion is. They have like even a term for people who defend Johnny Depp. You know, and it's really, really sad. I did not anticipate that there is a portion of society that is completely blocking off reality. They just simply, whatever reinforces their ideology, that's what they stick to. And to me, I mean, they've always been around. To me, I've just been introduced to that subsect of society, and it's frightening. And all you have to do is go on the internet and find some of these articles written by the lesser-known publications defending, you know, Amber Heard, everything be damned. And I did not anticipate that.
Well, we saw that at Rittenhouse, though, with the same, you know, people who were diehard going to ride that bomb right into the ground. But it's also been interesting watching the people's position is flipped. Like, we were, you know, they were coming in really hard for her, and now they're like, maybe not so much. I think he's winning in the PR battle. Whether or not he wins a single dollar, he's doing pretty good.
I wanna go to so this defamation has this one issue, and it's for me. And it's all about the actual malice standard for public figures and what actually is a public figure in current society. Because there's a strong argument that anybody on this panel is a public figure for the purposes of any criticism we may receive to anything we say online at all, which effectively opens us to just about everything, right? So
I'm not admitting that for legal purposes.
I don't. I said there's a strong argument, or there's an. I might have said strong. There's an argument that goes around that way. I think that's improper for public figure status. But this notion that you must present evidence of actual malice, especially in a case like this, where the entire allegation is made about something that no one can attest to other than the two parties.
Mm-hmm.
There needs to be a clear instruction that you can determine that if someone did lie, that they lied with the requisite level of actual malice if they're the only person who knows what happened. Like, because otherwise, hypothetically, I could just say, well, I went to Runkle's house and I saw him abusing a beer can or whatever. Like, and no one could refute it. And no one could prove that I knew I was lying about it, but I would be the only person to have evidence of that other than maybe Runkle. But he can't prove that I was intentionally lying. Maybe I misinterpreted it. Well, really? Like, come on now. the idea that she's accusing Johnny Depp of domestic abuse or domestic violence. However, I don't remember which phrase is particularly used, but either way, she would know if she is the recipient of domestic abuse or domestic violence, and in particular sexual violence. So the idea that she could not make the statements with knowledge of the falsity is ludicrous, unless she had a mental condition impairing her ability to see reality, which that has not been testified here. Whatever medical condition she has, her ability to perceive reality is there, and it's obvious in evidence that's been presented that she can show remorse, she can experience regret and things like that in their discussions. So I don't like the actual malice standard in general, but I really don't like that there's some demand of quote unquote evidence, because I think it puts in the mind of people that you need to produce a document, you need to produce a something. But in this case, if she did indeed lie about it, then she knows she lied. And there's no way around that.
Right.
Yeah, so many people are expecting like a signed confession or something, which you just aren't going to get.
Right.
But you can come as close to it as you can, and it's up to the jury to decide whether or not they actually get there. I mean, that's really the bottom line. Has there ever been any discussion? I know Nick, I don't know if some of the other guys have been following this as closely as I know Nick has. Feel free to chime in. Has there been any allegation or discussion about her suffering from anything along the lines of battered wife syndrome, battered girlfriend syndrome, or anything like that? Or has that been not a topic of conversation?
Not yet. I've seen articles about it on Twitter and stuff like that, that this is, that Amber Heard is it's reactive abuse, like her, I think is what they call it, where she's been abused, so she lashes out with violence at Johnny Depp because of her abuse, and that justifies her violent acts towards him. Which, of course, the interesting irony there would be like, well, that would apply to him if she were the first abuser. Like if she abused him, then his violence would be, and so the reactive abuse thing. But I have not seen it at trial. I assume we're going to get that from her treating psychologist. Yeah, I think that's very much on the menu. I don't think it's the best argument, personally.
I was just curious because it kind of goes along with the lines of like her actions, what she was doing, and so on that you just touched on, Nick. That's why I was curious.
Yeah. No, I assume we're going to get that in her case in chief. Depp's team, didn't bring anyone who would testify to that effectively, and they didn't ask the psychologist about that because I think they're worried that she would have said, yeah, she's not a victim of reactive abuse. Victims have a different set of symptoms, and she doesn't have them.
Right. Exactly. Right.
Now,
they exhibit certain behaviors and certain symptoms.
Right. Her treating physician or her treating psychologist is probably going to testify. And that testimony is interestingly kneecapped by the doctor when they said, yeah, treating physicians and medical care providers must accept uncritically allegations of abuse and treat the abuse. But their job is not to determine whether or not it occurred, because their care is therapeutic, not they're not forensic on it. So interesting testimony, but man, I'm juiced up after that argument. That was good stuff.
Same.
Oh yeah, I thought it was very good.
To Rodborn's credit, I thought he did okay. I think he could have come. Yeah. You mentioned something to UI guy. Notice the difference in confidence between the two. He knew he was going up to that stand to lose that argument.
Sure.
And
His tonality like completely gave it away. Like I can, in my experience, I mean, it's kind of difficult. Like the smaller the case, demeanor when you're just dealing with maybe a few days, maybe a month in jail is one thing, versus when you're litigating a case that has many years in jail, potentially on the line, for one example. But I can tell you from my experience, making a motion for a directed verdict, or in civil cases, motion notwithstanding the verdict, when you get up there, you literally anticipate you're going to lose. That's kind of like a running theme. So everything that happens is kind of anticipated. I have seen a directed verdict granted once in our courthouse in like the last decade, from my knowledge and experience. Maybe more than once, but one I've seen with my own eyes, and that was just a case that absolutely deserved it. But they're extremely rare to be granted, and when you actually do get one, I mean, there's no better feeling. It's almost like a grand jury returning a no true bill, and the case doesn't go up to circuit and basically gets dismissed. Again, extremely rare as well. I've only seen like one or two of those. So Rottenborn, when he went up there and to make his argument, he has to sound as sincere and accurate, I guess, as possible. But he knew, and you could tell by the tonality, the frequency of his voice, his attitude, that he has to protect the record. That's his job. Make sure that the argument gets made, and to protect it on appeal, basically, if the case does go to appeal, to make sure that the record is protected. But his, you can sense that the sincerity was not there. He had to say what he had to say, and then I think several times he even said, if I remember, he said not to waste the court's time. I mean, it's a dead giveaway. Like, I have nothing else, so I have to skip, as quickly as possible to finish this up, and then call it a day, sit down, and let the judge rule against me.
And some petulant shots there that I think were probably for Heard's benefit.
Yeah.
She's got to be the worst client aside from the fact that she's paying the bills. But I imagine other than that, but I imagine that other than the paycheck, she's probably miserable to deal with. There's probably a certain amount of keep her at.
Amber, I'm fighting for you. I went up there and I gave it to him.
I mocked his prepared speech, which is because he's got a better argument.
Their best argument is on that. Actually, I will say the fact that Rottenborn didn't get that headline struck immediately in court today is probably that's a demerit to that guy. That statement, how they have not gotten that thing struck is kind of funny. It's entirely based on this retweet theory, and I mean, I agree that when you retweet something, you in some way co-sign it to some extent, but I think you got to have a little bit more to it. But maybe it's enough. But I just think, from what I've seen in defamation cases, it seems like that was a slam dunk, getting that thing knocked off, and he wasn't able to do it. I thought that I've been approaching this case, if you look back, with the idea that only the two statements in the op-ed matter. One thing that annoyed me, though, that Johnny Depp's team has not made the argument on, and it bothers me. The ACLU testified, and they mentioned this, that the ACLU wrote the meat of the piece. They wrote everything. So when Rottenborn says, well, when you look at a publication, you have to take the publication as a whole, I would have made the argument in the alternative to the judge that actually you do not need to do that in this case, because Amber Heard made the two statements, the ACLU made the rest of them. And just because she co-signed them doesn't mean that suddenly she gets to make two defamatory statements in isolation and then claim that it's part of this greater work. She didn't make the words of the greater work. She specifically chose, when she had the opportunity to make statements, to make these two, and they should be looked at as independent defamatory statements, not part of a greater work. Now, they didn't need that. They won on the issues anyway, but I would have focused on that aspect of it, because to have testimony that all of the non-defamatory stuff in the article was written by someone else, and only the defamatory stuff was written by Amber Heard is phenomenal. And I think it goes right to the heart of this disingenuous argument that the other side's making. But that's me. I don't know. I'm maybe pedantic on it. I hate defamation so much.
Did you know that I was actually sued for defamation once?
Really?
Mm-hmm.
Did you just name them?
No, I posted something they really didn't like. It was a police officer who searched my client's vehicle and either planted or moved about a piece of evidence inside the vehicle from point. Basically, it was moved from point A to point B.
Yeah.
And I caught it and I publicized it, and he asked me to take it down. I said no. So shortly thereafter, he, well, it was about like 11, 12 months later, he sued me, and I litigated it for about, I want to say about 9 months or so. The judge ended up dismissing it in our favor.
That's a public official, so you get a little bit more deference there. And see, that's where I think if there's going to be an actual malice standard, I think it should apply to government officials acting in their government capacity. I think that is actually maybe appropriate. I don't like the public figure doctrine being applied in the current era to celebrities or anything like that, because I think, man, so okay, so Johnny Depp is public
now too.
right, but my point is, yeah, that I'm a public figure. In theory, I could cause a sufficient amount of damage by lying about some celebrity. And even though they have a platform, I have a big enough platform and could increase it by lying enough to outweigh any sort of benefit that they would have traditionally had. Public figure doctrine for celebrities came from they would have access to the media. So basically, they could go on a news station and just torch someone, and the little guy wouldn't have any recourse. But now everybody has recourse. We've democratized communication so effectively that anybody can build a platform. And we even had that chick who sued Cardi B, or who got sued by Cardi B and lost. I mean, she lost, sure, but she made a fortune and expanded her YouTube channel to over 1 million subscribers by making these defamatory claims. Like, so why should Cardi B have had to prove that she acted with actual malice? Now, thankfully for Cardi B, that chick admitted to lying all over the place. So I knew these were lies, and she said it, I think, in court even, because she's super smart. But that lady was able to grab 1 million subscribers, have broad sort of acceptance on these lies, and a whole bunch of people who believed her. And what, Cardi B's celebrity was supposed to overcome that? How? That's what torques me off about the public figure doctrine. I really hate it. I think we need to have a relook at it. Also, the public figure doctrine is unconstitutional and was clearly made during the civil rights era, and it was done with what we would call restorative racial motive. I mean, the idea was that this was a New York, this was a court, right? A court going, putting it down on a police chief who was going after civil rights movement members. I mean, it was made in that time. It's localized there, and I just don't think it's appropriate anymore. But that's me.
Well, hey, if you ask people on Twitter, Star Decisis is a suicide pact. Can't go back.
Yes.
Yeah.
That's
No
right.
backsies.
Take that, Japanese.
Yeah.
And turn the game.
Sorry, Kuromatsu.
Okay. I'm going to start reading a bunch of super chats. Feel free to pop in and yell at anyone.
I'll be back.
All right, buddy. Stormy. Oh, by the way, welcome to the stream. Runkle, how you doing, buddy?
Oh, doing all right. I'm traveling. I picked the best time to book a vacation.
You on a train right now?
I'm in an Airbnb.
Okay.
The ceiling above me is like 5 feet tall. There are no chairs in this Airbnb except a couch.
Wait a minute.
Really bizarre.
Are you in a hobbit hole? Like, what's
Yeah,
going
I'm
on?
kind of in a hobbit hole. It's this is not one I'd stay at again, but I'm popping on just as much as I can just because this is such a fascinating trial. It's such a gong show.
Are you anywhere fun?
I'm in Toronto, so
No.
well, kind of. I got to go see Movie Armaments Group and their vault, and they're film armorers. So many guns.
Yeah.
Didn't get to play with any of them, but I did get to pick up something that will be useful for when I'm talking about Alec Baldwin. Because
Ooh, nice.
I got some actual film-rated dummies. So they're actual film dummies for 45 long cold, and
Nice.
so I can show people a little bit about just what had to happen for him to be confused about this and how it could have been avoided. So,
How'd you like his police interview, though?
oh, I haven't watched all of it. I started. I saw you were on with the AK guy, and I was super envious. Because the place I was at that point was a different Airbnb, and the wireless there was super bad. I actually stopped watching just so that I could go in it, and I'll probably try to go and have a look at it fresh. But I got as far as he's in the room, and he's getting, like, he starts making a cell phone call, and he puts it on speaker.
Yes.
And I'm sitting there going, no one else is allowed to have their cell phone in there. So they're already treating him a little differently, because anyone else would be saying, like, we're going to take that.
Yeah.
B, are you kidding me? How stupid can you be? Like, oh.
You may not have gotten to it yet. He does make another call, and he goes to headset mode, and the best part is you can hear every word.
Oh, yeah. Those people don't understand.
Those
Those
windows
windows.
that place.
Yeah.
Yeah.
Sometimes you get guys who've been arrested and they mutter to themselves something like, oh, I'm so fucked. And they say it just real quietly. And you can pick that up just perfectly. And then the Crown or the prosecutor will play that back and forth and be like, so why did you say that? And,
Yep. When you are brought in to a police station, don't say shit to anybody at all. Your phone call should be to your attorney saying, "Get over here now. I need you. I've been Mirandized. Get me out of this."
if you fart in there, the audio is so good that they can tell what you had for dinner.
Adequately put. Well, have fun watching that. It was really it was a phenomenal interview in so many ways, because you're just like, okay. So I think you'll enjoy that. Stormy says, "Will they cover the witness chair with plastic before Turd sits down?" That would be so epic. Hyperion. Woot woot, 7 months. You make the days bearable, man. Oh, thank you. Dennis Heaton. It's officially Amber Heard Day. May the turd be with you. Coincidentally, it's also poker night. Deuces wild. Farmhand. Farmhand says, "Hey Nick, just another advertisement for Farmhand Tom. You sell it better than I do. Hope you got the sample." I did get the sample. I have not had the opportunity to use it yet, but Farmhand Tom, you can look him up on Google and go check out his store. He has the Amber Heard odor removing spray, perfect for any linens you may have that might have been soiled by a vengeful, vindictive bitch of an ex, or any other reason. Maybe you got pets or something. Check it out. It uses natural enzymes to break down odors, and you can get it on Farmhand Tom's webpage there. Justin Wright says, "Has Olga always been sitting behind her?" Who's Olga? Oh, I see the big chick. Yes, she's been sitting behind her for most of the trial, if not all of it. Yeah, I think she's their research attorney there in the courtroom. Matthew Self, Nick, you have a lot of murdering to do. I do. Multi-jurisdictional, probably multinational murdering is coming for all of your OBS comments, chat. And you're all getting a cat with it. So, Dr. Spoon, Nick is going to put you in a live trap and drag you to a pond like that.
Yes.
What else are you supposed to do with a skunk? I don't know, man.
You don't have rifles where you are?
It was in a live trap, and I didn't look. I had to shoot a skunk that got stuck in a window well once, and it sprayed everywhere. God, it was a mess.
Now you're talking about a different one that you killed. No, we're talking about the one you did ISIS style on the lake.
Yeah. Well, look, it got stuck in a live trap, and I won. Actually, I think at the time I might not have owned a gun yet. I can't remember. But no, so I knew if I tried to release the thing, it was going to spray everywhere, and I couldn't do that. I was driving to Texas that day. So it was either, drown it or it was going to die in the trap while I was gone. Eric P., the abortion thing makes no sense. If liberals want to kill their kids, what's the argument? I mean, I could go into it. I don't know if we really want to. I believe that a government's duty is to protect the life of its citizenry, and I see a baby in a womb as a citizen of the government that has
Also,
some duty to intervene.
Yeah. And last night, are you asking about people's thoughts on it? I gave you a super chat last night. Those are my thoughts on the whole thing.
Oh yeah.
That was good. Yes, the government implements of questionable chastity will be very upset.
Yes. Garden tools be angry. Wizard Brain Lou, I saw Amber Heard is on Wednesday. I do hope it's today. If you had to bet some money, how long do you think she will last on the stand? I think she will last, but Johnny Depp has to know what will trigger her, right? How long do I think she'll last on the stand? I mean, she testified for 4 days in the UK trial.
I'm hoping these lawyers just are good at prodding her, because I think if they take the right approach, they could get her real wound up and real pissed. But we'll have to see. Especially because this judge appears to allow a fair bit of leeway in that regard. And so maybe they could get her spun up. That would be wonderful to see.
Yeah, I think a strategy they might try to employ is something, where they try to limit the scope of cross-examination by having a very limited direct on Amber Heard. But the only objection for outside the scope was overruled in this case. And I think the objection was proper. I think this judge is going to let this one go. It's similar to how Rittenhouse, the judge is just going to let a lot of testimony in if you can manage it.
So high profile, they're not going to want to face accusations that they had an unfair trial because they excluded too much evidence. But of course, then you can get unfairness because you've included stuff that shouldn't have been in there in the first place.
Right. But it's really hard. It's going to be really hard to get any decision in this case overturned on a judge's evidentiary ruling, unless it was abusive. It's abuse of discretion, I think, and so it has to be. It has to be very, very wrong, and the judge has to basically be choosing to abuse their discretion in the favor of one party over another. And in this case, she's been equally bad on objection rulings, so I don't think you can do it.
No.
Let's see. David Hayter's last night's stream was almost as good as when Drex and yourself roasted Jack Murphy for 3 hours. Last night's stream was great. Contagion. Fact that RVW is potentially being, Roe vs. Wade potentially being overturned is shocking enough, but timing is a bit sus as well. What are the chances it's just smoke and some SJW intern supporting Amber Heard cause leaked to try and divert attention from testimony? There is zero correlation. I will go to my grave that there is zero correlation between the release of the potential Roe v. Wade decision and the Amber Heard Johnny Depp trial.
Yeah. And nobody's going to fake writing an entire decision, because unless you've done that kind of legal writing, it's a ton of work. And I mean, nobody's going to do that as a prank.
Yeah.
No.
And if you're if you're looking for some sort of like conspiracy or reason that this could be leaked as a distraction, I mean, actions in Ukraine are far more up the government's alley, like getting us into, for example, hypothetically getting the United States into a proxy war with Russia in Ukraine, or even a direct war with Russia in Ukraine. Concealing troop movements or something. Those are things.
Well, mass destruction.
Right. Well, There's some statement that we would, if Russia were to use chemical or biological weapons, that we would directly intervene at that point or something.
Yes.
And so, like, I'm not saying this happened because I don't think it did, but that would be, I would go there long before I would go to, there's a huge line of things before Amber Heard's testimony for me. Ryan says, I guess we know that Amber Heard will be auditioning for the role of the Phantom in the next movie adaptation of the Phantom of the Opera. Ben Hagstrom, I've been loving these streams. Hope it's okay to show my podcast, Good, Better, Benjamin. We talk about escaping monsters like Amber Heard and getting back on track from a guy who put in the work. It's on Spotify and Apple. Thanks. Hey, thank you, Ben. Good, Better, Benjamin, if people want to check that out. NSX.
Actually, I gotta head out.
All right.
I'll see you later. Testing to you.
Yep, peace. And, well, there's going to be three of us once he leaves. Leave! Get out of here! NSX says, Amber watched you school Destiny on Transel Culture, Nick, and is now trolling you. Tomorrow she may mirror you with a guy haircut. Oh, yeah, that'd be fun. She should do it. She should do that. Jay Frozen says, hey, long-time enjoyer of your streams. First started watching during the Vic case. Cool to see you grow. I'm also a fan of Nick Fuentes, and I don't believe you described his politics well. Bring him on a stream. I probably did not. I'm not super familiar or interested in America First or Nick Fuentes' political positions. Not because I have any animus towards them, but because I don't really subscribe to any particular ethos. I'm hipster enough to have developed all of my own opinions on all subjects at all times. So that's just me. But bringing Nick Fuentes on the stream isn't super appealing to me. But, you know, it would always depend on the topic. Kevin Exner says, when the Google Analytics expert witness was spying on Cross and was asking for his report to be pulled up, what motivation does the defense have to not pull up sections of his report? Well, they're bad for them. I mean, that's the simplest answer. He didn't want to pull up those articles, probably because those articles were referencing the hit piece, the Washington Post opinion piece. And if any of those articles actually reference that thing, it destroys their narrative that his analytics didn't really factor in that at all. Corn Pop says, are you Republican or Democrat? Just wondering. I'm a small L libertarian, and that right now that tends to have me voting Republican more often than anything else. There is a feasible theoretical place where Democrats return to some sanity and Republicans go like full authoritarian, where I would switch. It's feasible. I don't know that it's likely in any new timeline. So if you need an R or D label, I trend to R. Let's see. Next, Sarah Moore, welcome to Paralegal Status. D. What? Welcome to Paralegal Status. Thank you. Winged Paragon, do you think they will have Heard's team's psychologists take the stand first in order to damage mitigate Dr. Mommy before Heard takes the stand? Also, couldn't she be impeached for firing her PR team? No. Witnesses and outside research. I don't see how you can impeach her for firing her PR team. Her PR team isn't at issue in the case. It has not been raised. I don't see how you get there for anything.
You'd have a tremendous obstacle on relevance. And even if you could get it in there, you could just be like, yeah, I fired the PR team because, you know, they're doing a poor job. But it would be a really dangerous line of questioning, because you could basically be saying, well, you know, the media is, you know, maligning me. Look how much this plays into the whole abuse thing. They're not going to go there.
Yep, it would be a mess for them, and of no real profit to go after it. But as for the first question, my thoughts, I would put Whitney Heard first, and I would put Amber Heard last. That's how, based on what I and I do not know, I do not have encyclopedic knowledge of her witness list. I don't know what else. To me, I think there's power in imagery And I think having the two sisters bookend all of the rest of the testimony with their firsthand accounts of abuse. The only, like, it'll be the first actual account of abuse of Johnny Depp versus from Johnny to Amber that we've heard would be Whitney's testimony. And then, of course, Amber Heard's personal testimony closing it out with the emotional pull and everything. That's how I would do it. And I think that, again, I think that the imagery of the abuse being booked into